Welcome to Litigation and Capital.
Hey everybody, welcome back to an all-new episode of Litigation and Capital with Stephen Mirsky, partner at Mirsky Corporate Advisors. I'm your host, Mike Leon. In each episode of this series, we break down high-stakes legal issues affecting companies like yours, those earning $10 to $100 million a year, so you can turn complexity into leverage and protect what you've built. Stephen, good to see you. Let's get into protecting what you've built, like I just mentioned. So disputes happen all the time. In your experience, what kind of disputes are most likely to be resolved by the threat of litigation before a case is even filed?
Thanks, Mike. Nice being here. Turning to your question, I think that if a company has significant lines of credit with a main bank, one of the major things that they have to consider is whether or not they've defaulted under material contracts. Oftentimes, when you have defaulted under a material contract, that too constitutes a default under your main credit line. And so the threat of litigation or a notice of default or something like that may be strong enough to kick business teams into action because they don't want to violate their underlying credit agreements. So it's a very powerful tool in certain cases. Then again, there's other companies that don't care. And so, you need to find different avenues to resolve the potential disputes. But generally speaking, if you are a well-run mid-sized business, you're going to want to make sure you're not violating your covenants with your line bank. And so, the threat of litigation in and of itself is likely to resolve the dispute.
Stephen, we were talking about this off air about demand letters. I would love for you to kind of explain, first off, what is a demand letter, but also what elements make a demand letter credible enough in reshaping negotiations or something that happens where shareholder conflicts. Can you kind of explain it?
Sure. So a demand letter is a letter that sets forth a demand. We want you to do X because of reasons A, B, and C. The demand letters are typically 3 to 5 pages. They can be longer, they can be shorter, but it's setting forth what you want, why you want it, and the rationale for thinking that you will be able to obtain what you want. One of the great benefits, in my opinion, of a demand letter is that you kind of create a record for any future complaint that you're going to file or any future defense that you might have, because you can, it's not settlement negotiations, it's admissible evidence to the court. And so it's a good tactic, I think, for framing a dispute, especially if you think the dispute will be unresolved. I think, too, it tests the caliber of opposing counsel on the other side. I've seen demand letters go out where opposing counsel had wonderful responses and said, okay, look, we've got a good professional team on the other side. Let's make sure that we evaluate this more closely. I've gotten responses back that are like, did a child write this? So, and that gives me a sense of, all right, we may have the upper hand here if we proceed down this path. So it's a good tool to test the waters, and it's a good tool to frame the issues. What makes it credible enough to move to the other side? Think about it as an opportunity to briefly present your factual and legal arguments. Do you have credible legal authority to back up your facts? If so, cite to it. Now, don't make it a very long, drawn out paragraph, but, put it out there. If opposing counsel is going to review it, then make sure that they can read it.
So let me ask you, because I love, in a previous episode, you explained some of these acronyms and the terminology as well. So I'm going to have you do that right here. But let's talk about pre-litigation tactics. There's a few out there, TRO threats, you've got draft complaints, you've got regulatory referrals. Explain what those are. And in your experience, which approaches in these high stakes disputes has probably carried the most weight or been the most effective?
A TRO is what's called a temporary restraining order, and they are extremely effective because they maintain the status quo, and they turn into what's called a preliminary injunction, which means that, hey, we're going to maintain the status quo for the duration of the case. They are a very powerful tool. Courts do not like to grant them because they are so powerful. It's kind of like fast forwarding the trial and putting it all at the beginning, because the court has to say, hey, look, does plaintiff have a likelihood of success on the merits? And will the plaintiff suffer irreparable harm if the court does not intercede today? This is very common tactic used for trade secret disputes, and where you have an employee who's left your organization, has gone to a competitor. It's a very common practice to prevent the dissemination of that information that could potentially undermine your own business and give your secret sauce away to your competitor. Drafting a complaint. So a complaint is the vehicle that we use to tell the court you want to redress some wrong that's been done to you. And so oftentimes you'll see a demand letter that has a complaint drafted and attached to it. And so the response and the reason why that's the case is because the sender of the demand letter wants to say, hey, look, we're ready to rock. So it's time for you to come to the negotiating table now. This is your last chance. Regulatory referrals. So depending on the industry that you're in, there are certain state and or federal regulatory agencies that govern what you do. Let's say I'm a contractor, you have the Contracting License Board. If you're a lender, in California, you've got the Department of Financial Protection and Innovation. If you are a radio broadcaster, you have the Federal Communications Commission. So there is a variety of regulatory avenues as well. And so what you could do is you could file a complaint with those regulatory agencies and have them investigate the counterparty. From a legal ethics perspective, we can't threaten to file some sort of complaint with a regulatory agency in the hopes of obtaining a better outcome in the negotiation that violates the rules. But there's nothing that prohibits you from just filing something and still trying to negotiate. You just can't use the threat of filing something to gain leverage in a negotiation.
Stephen, take me a little bit inside your process of when you're advising an executive. How do you decide whether, hey, we want to aggressively get litigation on the books here, or, you know what, let's hold back, let's preserve the business relationships? Take us through a little bit inside of how you would process that, how you would advise an executive on that.
The first thing I would do is look at what is the fact pattern of the underlying case and our objective. If, for instance, is the harm going to be extreme? Is there something patently unfair, or is there, we're hurt a couple $1,000 and, we kind of want to do this, but we don't really want to move forward. I think those are initial considerations, right? Because we have to figure out what's the harm here. The harm is going to drive our course of action, and is also, from a business perspective, going to say, hey, is the juice worth the squeeze? Am I going to get an ROI? For instance, if I have damages of 20 grand and it's going to cost me 20 grand to get 20 grand, well, that doesn't make any sense. Why would I engage in litigation? So that's one of the first things I would look at. The second thing I would look at is what is our overall objective? Obviously we're trying to redress some sort of harm, but is there a broader picture, and how does this action fit into our broader strategy? For instance, let's say that there's some dispute that arises with a vendor, but I am also in a company that's entering into an equity financing round and I need to raise money. Do I want to disclose to my investors or potential investors that we're currently engaged in litigation, or we have a pending lawsuit, or would I prefer not to raise that issue as we seek to get more money? Some of those considerations that would go into that are, is our financing round to get us more nice to have money, or are we on our last legs? We absolutely have no runway, right? These are all considerations that would come into play as whether or not we would want to move forward. Conversely, let's say that we're a really well-established business. Let's say that I'm a owner and I'm trying to exit because I've been doing this for 30 years and I'm tired. You know, do I want to engage in litigation after I have an LOI signed? Or do I want to just make this problem go away and then let the buyer deal with it? These are all strategic considerations that need to be analyzed at the time we decide how we want to handle the underlying dispute.
Yeah, it's a good thought process. People don't think about the ancillary part of this, right? Investors, lenders, et cetera, et cetera. So let me ask you, because I'm a poker player, so a lot of people bluff, right? And you got to call them out on the bluff. What risks do companies face if they bluff with the litigation perspective without being able to follow through on it? And how do you mitigate those risks for the clients?
I don't bluff. That's one thing I don't do. I just either do something and then talk, or I talk and then we do something. But there's no bluffing because it undermines, I believe, your credibility as an attorney to the other side. That said, there's plenty of other attorneys who bluff, and everyone has their own style. So I think for me, that's how you remove the poker element of it, and you get it back into the strategic component. Because litigation, at the end of the day, is about control. Who's driving it? Or let's think about it like a football game. You're trying to drive the tempo and do clock management towards the end of the game. This is what we're trying to do from the outset. We are trying to drive the bus, and we want it to drive it the way that we want it to go. So another aspect about bluffing is, and if you're unprepared to follow through, is that you've lost the initiative, right? Depending on where we are in this process, we want to make sure that we are in control. And losing the initiative is a huge strategic issue. For instance, let's say someone says that they're going to sue me if I don't do something by XYZ date. I tell them to pound sand. I'm not going to do anything. I'm not going to respond to their letter. Nothing happens. Nothing happens. Nothing happens. Now I go on offense. Now they have to play my game, right? That is a situation where the other side might not like it. If I'm defending a case, maybe I'll call their bluff. All right, do it. Your case is garbage. Let's see it. I'll gladly defend their case and make you spend a lot of money to prove that you have no case. So it depends on where we want to go with this, and also the temperament of, a lot of it is the temperament of the business teams. Certain executive teams are very conservative, and they're just like, let's just figure out what kind of money we got to pay and just be done with this. Other guys are like, F this dude, F that dude, let's go to war. And so the understanding the temperament of your client and their business team certainly dictates the strategy and whether or not you're going to continue with bluffing or respond to a bluff.
I love the sports references because I get every single one of them. So, Stephen, let's land the plane on this, because we talk about readiness just as an NFL team would prepare to be ready. How can litigation readiness be used proactively by whether it be your clients or executives that are listening to this? And is it used as leverage in deal making, restructuring, or just as a competitive strategy?
You want to use litigation judiciously. Right? If I am a company that sues all of my suppliers, well, then no one's going to want to work with me, right? Or if I am a company that sues all my customers, it's going to be a lot harder to close that next deal. So there is something to be said about restraint. That said, your internal legal team or the decision makers within the organization need to have someone they know and trust on standby that understands the business, that understands the goals, and is ready to move when they need to move. And that would be my recommendation is it's like an earthquake safety kit. Make sure you have one. Hopefully you never need to use one, but make sure it's ready to rock when the time arises.
As always, earthquake safety kit could be the title of the episode. Stephen, I can't thank you enough for the time and insights on this. We truly appreciate it.
Thank you.
And thank you to everybody out there listening to another episode of Litigation and Capital. If you want to connect with Stephen and the team over at Mirsky Corporate Advisors, do me a favor, visit MirskyCorporateAdvisors.com. Found this episode helpful. Don't forget to subscribe. Leave us a review, comment, share it with somebody who needs to listen to it. As always, I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.